Hello, I am Kathleen Hamill, and on behalf of the American Bar Association Task Force for American Democracy, I am delighted to welcome you all here to our discussion on protecting the federal judiciary. At this critical time, the legal profession is at a significant inflection point, and we will examine questions related to judicial authority and what's next. We are joined by three legal experts: Judge Paul Grimm, Judge Nancy Gertner, and Professor Richard Pildays, who will help us to explore key questions related to attacks on the federal judiciary, including threats, intimidation, and defiance. We will focus in particular on compliance with court orders and what happens in the face of defiance. We know that judicial review is fundamental to maintaining the rule of law and the separation of powers established by the United States Constitution. And our rule of law framework depends on an independent and impartial judiciary, as well as a right to counsel, attorney independence and candor, and due process. This framework also depends on compliance with court orders by the powerful and by the executive branch of government in many cases. Today we are seeing calls for impeachment of judges and congressional hearings on activist judges. I wanted to just take a second at the outset here and refer back to a week ago when the Chief Justice John Roberts responded in his own words to his own question: what is the appropriate response to disagreement concerning a judicial decision? Chief Justice said, for more than 2 centuries, it has been established that impeachment is not an appropriate response to disagreement concerning a judicial decision. The normal appellate review process exists for that purpose. With that in mind, our program today will discuss several key specific questions, but it will also allow for a broad-ranging conversation of many of the challenges to our rule of law and to our legal system here in the US. So to get us started, I would love to just note that the full bios of each of our esteemed panelists will be posted in the chat. But Paul Grimm, Judge Paul Grimm, is the director of the Bolch Judicial Institute at Duke University Law School. He's a former district judge, federal judge, and he is currently the David F. Levy Professor of Practice of Law at Duke Law School. Given the incredible experience and expertise that Judge Grimm brings here to us today, I thought I would just start by asking him to share his views on what challenges and attacks are currently facing judges. What's your view on what's happening? How does the situation today look from your vantage point? And as we move forward with our other panelists as well, I would just say we are looking here towards the current situation and what's ahead, and what can we as citizens and the public at large do to make sure that the rule of law is upheld here in the United States of America. So thank you, Judge Grimm. I will hand over the mic to you and let you talk and share your views and perspectives with us.
Thank you. Well, it's not a surprise to anyone that for well over a decade, public opinion polls about the American judicial system have shown a sort of a decline in trust and confidence among the public in the judiciary and in judges. And there are a lot of reasons for that. And we have had for the last 5, if not longer years, an increase in threats against district judges that have been investigated by the Marshal Service and determined to be credible threats. And it's doubled, I think, in the last couple of years. Moreover, criticisms of judges for having ruled in cases and issued their opinions is not particularly new. We've seen that in the past 10 years on the increase, and it has come from both people on the right-hand side and the left-hand side of the political spectrum. and personal attacks against the integrity or the motivation of judges has been on the rise. I think the more immediate recent history has shown, however, that qualitatively and quantitatively, there is something different. There were calls for impeachment of judges sporadically in the last 5 or 6 years. There were attacks on individual judges with regard to rulings they've made in cases. But what's different now is the fact that the Chief Justice of the United States in his year-end report on the American judiciary specifically spent the overwhelming majority of the substantive aspect of his report talking about examples of illegitimate attacks on the judiciary that include intimidation, threats, misinformation or disinformation, and attacks that are based upon simply ruling on an opinion, and the importance of the rule of law to our society and the importance of judicial review. And more recently, just a week ago, the rather exceptional comments by the Chief Justice in the face of a personal attack on a particular district judge for rulings that that judge made in cases that were assigned to that judge. And that's something that is different in scope and magnitude. And we've had these attacks have been leveled at judges appointed by presidents from both the Democratic and the Republican Party. So the notion that judges are above criticism is not anything that anyone is saying. We're all saying that judges are public servants like anyone else, and what they do can be criticized. But the vituperative nature, the threats that call out the call judges terrorists or call them radicals or say that they're traitors is different in tone, and when it's coming from a lot of individuals who are high up in the government and resonates and is shared online and magnified many millions of times, then that is what creates a situation which is significantly different than what it has been in the past, more concerning. And I think that's why the Chief Justice issued that statement that he issued last week. These are qualitatively and quantitatively different. The dialogue in impeachment is such that people overlooked that in the history of the United States, only 21 or 22 federal civil officers have ever been subject to actual impeachment trials and proceedings in the Senate. 15 of those have been judges, and 8 of them have been convicted or actually impeached on a 2/3 vote of the Senate. But the type of conduct that they engaged in is fraud or abuse or corruption, or in one case, just during the Civil War, a federal court judge refused to hold court and declared and fought against the United States. So these were the kinds of activities that everyone would agree is high crimes and misdemeanors. It was corruption or perjury or something of a very severe nature. Never, as the Chief Justice has said, has it ever been seriously asserted that a federal judge should be subject to impeachment just for trying to rule. And the truth of the matter is that the tool with which the crucible with which these kinds of attacks have come out have tended to focus around injunctions issued by an individual district judge. There's a lot of criticism on these nationwide injunctions, and there have been calls to look at that in the past. But the key is that there have been, since the 1960s, there have been nationwide injunctions issued against every president in the last 25 years. And so this device, which is somewhat controversial, and that some people think that it's of questionable constitutionality, and others think that it's essential to being able to do equitable relief in certain types of cases, is certainly something that could be looked at in terms of whether or not that process should be refined. But simply to say that a judge who is ruling on a temporary restraining order and with a ex parte, according to the rules, allowed ex parte filing and gives a brief stay to be able to preserve the status quo, to be able to get rulings from both sides and then be able to rule on it, is somehow intentionally thwarting the rule of law and interfering with the executive's agenda. Well, as the Chief Justice said, there's a remedy for an incorrect decision, and that's called an appeal, and there are mechanisms to do that. So the tone, the frequency, the amplification, the level at which these attacks are coming, and the frequency is something that is unique and I think quite concerning.
Thank you. Thank you. The tone, the frequency, the escalating fervor, I think is something we're all seeing. And Judge Gertner, you've spoken out about this and welcome your thoughts as a former U.S. District Court judge and a current law professor as well. I would really welcome your experience, your expertise, and your thoughts on the proper role and authority of the judiciary, as well as what we are seeing here across the entire legal system today.
There's a wonderful line in the State of the Court report that Justice Roberts filed in December of 2024, in which he says, criticism comes with the territory. And criticism obviously comes with the territory of being a public figure, as a judge is. And I second what Judge Grimm is saying, that this is really dimensions different. It's dimensions different because of what it's responding to. So these are criticisms with respect to TRO's 14-day orders, as if doing that was somehow leading the republic to fall. In addition, these are not criticisms. You did it wrong. I disagree. These are threats to impeach. And let me take it one step further, actual articles of impeachment. Articles of impeachment, I believe, have been filed with respect to 4 of the judges who ruled in ways that some disagree with. And then the other difference is by whom. This is also in Justice Roberts' 2024 report. It's different when public figures who should know better talk about impeachment, talk about treason, and challenge judges in the way that they have. Finally, it's very different when public figures are talking about not complying with court orders. I've been around a while. I've never heard of that before. You can disagree, you can appeal, you can write a law review article, you can write an opinion piece, but the threat of not complying is a very different situation, as well as numbers of people have talked about. President Nixon complied with the Supreme Court order to turn over the tapes, even though he knew that it would be devastating. So the threat of non-compliance. Let me add one other piece to that. From what we understand, it's not just the threat of non-compliance, it's actually actual non-compliance in courts. A Department of Justice official doesn't bother to show up. Judge asks for an explanation, none is forthcoming. This is a degree of lawlessness in the courts that we just have never seen before. And so I appreciate Justice Roberts doing something really out of character in the sense of intervening in a way and with a statement that he's never, not coming out and not something that he would say as part of the regular course. He sees that this is not the regular course. And so he's intervening to make the statement that impeachment isn't the way you deal with judges who you disagree with. Appeal is the way you deal with judges you disagree with. And the appellate courts have been enormously responsive to emergency appeals. So that essentially the president has gotten review when he has wanted it. He's gotten expedited review to the Supreme Court when he has wanted it. So there's no reason to go around the usual processes and begin to threaten things that we have never heard of in this country.
Thank you, Judge Gertner. In terms of Professor Pildes, your thoughts on what we've already covered here and your view on the situation, specifically to going to the question of what about defiance? And you've written an excellent piece that sounded the alarm over a month ago now on some of this, and I'd love for you to help our audience understand really what some of the guardrails are, what some of the options are, and what can be done to reinforce and uphold the judiciary at this time.
Well, thanks, Kathleen, for hosting this. And I'm very honored to be part of the bipartisan ABA task force on American democracy, and also honored to be part of this discussion with Judge Grimm and Judge Gertner. I would make two initial points. The first is just to remind people, we tend to take for granted the benefits that flow from having successfully managed to establish over many, many generations the institution of an independent judiciary and the rule of law, under which public officials are accountable, not just to elections, but to the law. These are enormous political and cultural achievements. And the benefits from these structures, from these understandings, are what enable a sort of stable institutional framework within which people and businesses can have confidence that their personal rights, their economic rights, contract and property rights will be protected and not subject to arbitrary or political manipulation. And it's not as if the domain of law is separate from the rest of the economy and society. I mean, to the contrary, this is part of what enables the American economy to be as strong as it's been historically, why people invest resources here in the United States. And so I just think it's important to understand, how central this is to a thriving political, economic kind of system, the independent judiciary and the rule of law is. And then the second point I'd make initially is there are a lot of ways to weaken or undermine or sort of thwart the independence of the judicial system and undermine the rule of law. One, which the two judges have talked about already, is efforts to intimidate or threaten or impeach judges for decisions that political actors disagree with. Again, vociferous criticism of decisions like these debates we're having on nationwide injunctions, that's perfectly fine. The Supreme Court will ultimately have to address that issue, but that's very different from threatening or intimidating or threatening to impeach judges for decisions you don't agree with. A second way the independent system of law and courts can be undermined is by efforts to intimidate lawyers and law firms. And, again, there's room for sort of charges to be brought against specific individuals if they have done things for which there's a legitimate basis for raising ethical or other kinds of issues about their conduct. But again, that's very different from efforts to threaten or intimidate lawyers and law firms for bringing actions against the government, for unpopular causes and the like. And then a third way this system of the rule of law and independent judiciary can be undermined is by turning the Department of Justice into a partisan tool. And then the last that I'll mention here, which Judge Gertner alluded to already, is then actually define court orders in specific cases. And I don't think we are yet at that point where that has happened, but we are dangerously close to that point. And there are certainly actors in the government who have said a variety of things that suggest their willingness to defy the orders of the court, but the administration has asserted in court that it has not defied any court orders yet. No judge has made a finding that that's taken place yet. And I do want to be a little bit careful. I don't think it's good to get ahead of our skis too far on these issues, because these are very, very charged issues. And if we get to the point of the executive branch defying a court order, that is crossing a huge red line. And that calls into question the actual stability of the rule of law, the existence of the rule of law. Even Professor John Yoo at Berkeley, who is offered up probably the most robust conceptions of executive power of any academic, has said this would be a huge red line and the administration should not cross it. and there would be very, very damaging consequences if it did. So let me stop there with my initial comments. So I'm happy to respond a little bit more concretely to your question about what tools the courts have if individual government actors do cross that line.
Thank you. Thanks. That's very insightful. And I wanted to then ask you, Judge Grimm, if you could weigh back in terms of what our other panelists now have commented on, and perhaps to share from your perspective, how judicial orders actually can be enforced in the face of defiance, and as well. Is this about red lines, or are we at a point where this is almost a virus? And as some of the other legal experts in our wider community have alleged, Judge Grimm?
Yeah, I think that let's start with the more specific question you asked first, is that judges have a series of tools that they can incrementally use when an order has they are trying to determine whether an order that they have issued has been violated. Now, you would think that that's a clear decision one way or the other whether it's been violated, but you've seen the kinds of things that lawyers do all the time. They parse words and they parse concepts. So, well, does the order have to be written, or is an oral order sufficient? What level does the order become one that's enforceable? If the judge says something in open court, but the written order does not include that language and is more specific and was written afterwards, which one controls? Those are all within the realm of what judges deal with when there's an issue as to whether someone has violated a court order. And these are not unusual questions that get asked sometimes. We see all the time in civil discovery and other things when one side comes in and says, Judge, you ordered that they do this, they didn't do that. So the courts will make an inquiry. You've seen that happen when there has been some question. The judge has asked for further information. Now, it would be, the parties typically, not necessarily always willingly or quickly, but eventually provide the information. If there's an assertion that that's privilege, then of course the judge has to deal with the privilege and go through all those mechanics. Ultimately, the judge has available civil contempt, and that can result in an order that a government official has not complied with a court order. The purpose of civil contempt is to be coercive, to try to get the parties to purge the contempt by doing that which the court ordered them to do. That can result in civil fines that can magnify over time, or holding a particular civil officer in contempt. The question then is, well, what happens if they say we don't care about the fines and you can hold me in contempt all you want? Then at some point, then the judge, has the power of contempt includes the power to coerce compliance, and that can include even in the civil context. There are certain procedural safeguards in there in order that that person be detained until such time that they purge the contempt. I think that what you'll see, and I think what Professor Pildes was so correct in pointing out is not to get ahead of your skis. It hasn't happened yet. And the kind of maneuvering as to whether or not the order was final or not, those have not been resolved in any order by a court that I'm aware of, finding that there has been a violation and then addressing the need to take on contempt. At some level, if there's a disregard, then and the appellate courts have ruled in, and I think that there's some difference in scope that some folks have in mind about, well, is it the same if there's some question about compliance with a district court order as opposed to a circuit court order, as opposed to an order of the Supreme Court? We can hope that we don't get to that to experience to be able to know the answer to those specific questions. But there are other things too, and I think it's very important to remember what Professor Pildes said that I think is so important. There are benefits of the rule of law and compliance with judicial decisions that have led to us having the kind of country that all of us take pride in. And certainly, I can't imagine it's in the interest of businesses or in the long-term interest of the governments to have a non-functioning legal system. If the rule of law collapses, then there is no right, privilege, or benefit that we have as members of this country that is not in jeopardy. And
Let,
so
let
I
me
think
let me
that,
interrupt for a second. If you want to finish that point, and I want to turn Judge Gertner to you to respond and to perhaps help us understand, are we already past the point where orders have been defied? And are we maybe not being sufficiently concerned at this moment? Judge Grimm, please finish your thought, and then I'm
don't
gonna.
say we shouldn't be concerned, but I'm not sure that we're at that point where we have gotten to the point where we have seen some behavior that has manifested itself in a way that we could say that the system has come to a collapse.
Fair enough. Fair enough.
I'm hesitant to say that we're at the point, but frankly, I think we are incredibly close. So what you have seen is judges indulging the government and hearing after hearing. I'm looking particularly in Rhode Island, Judge McConnell's case, where I think he's on his third motion for clarification, sort of giving the government the benefit of the doubt and clarifying what he's asking them to do, giving them the benefit of the doubt in ways that other litigants may not have been given. Likewise, Judge Boasberg had an apparent violation of his order, and he's seeking to find out more about that. The government is not easily cooperating with that, claiming that they don't have to, claiming state secrets, that they don't have to disclose that to him. Certainly there may be classified information involved, but there is we know how to deal with classified information. Judges deal with classified information in a host of ways. So I think you've seen a great deal of brinksmanship on the one hand by the government, and then you've also seen judges indulging the government because they don't want to draw a line in the sand and have the government that sort of cross over it, which is not a bad thing. But when you look around the country, I think that the government, the administration is coming awfully close to ignoring what the judges are doing and saying. And as I said, this is in a framework in which there has been ready, appeals of temporary restraining orders, which, as I recall from civil procedure, is not supposed to happen, at least in most cases. So the government is being indulged in a number of ways, both the adequacy of appeals, the expedition of appeals, and then these reviews of what the compliance has been, giving them as long a string as they have needed so far, precisely to avoid the moment that Judge Grimm was talking about, precisely to avoid that. But there's only so far you can go down that road before we're going to wind up with a more explicit confrontation. And then I might add, there's also the reports. I don't know if they're true, that some of that there's non-compliance, which actually have not been brought to the attention of the courts. Grants that were supposed to be reinstated that in fact have not been reinstated. Sort of implicit civil disobedience in some cases. So I think we're close, and that's very troubling.
Thanks. Professor Pildays, can you now circle back in on where we are with this, and based on your own analysis and understanding, what is it that we are looking at in terms of the actual problem here? Is it as narrow as a red line, or are we facing something that's much larger?
Well, I think, as I mentioned, there are a number of different dimensions along which an administration can act to weaken the sort of legal system as a whole. And that's not simply about the question of defying a court order. The executive also has significant power to kind of take unilateral steps that can be hard to reverse, even if the courts end up deciding that those actions were illegal. And even if the government doesn't defy the court order going forward, it's not always easy to, remake the omelet. And those issues certainly are present, it appears, with, for example, grants to contractors or organizations being cut off so that people end up having to find other jobs. The organization closes before the courts actually can come into the picture. So I don't want to underestimate, that side of the situation. But in terms of the issue of defying a court order, which is really the ultimate confrontation or the ultimate kind of challenge to the rule of law and to the independent judicial system, there are some other tools courts have available that we haven't discussed yet. So, for example, if lawyers misrepresent factual matters in court, they can be sanctioned for that, including government lawyers. If lawyers are involved in defying court orders, they can be sanctioned for that. The courts, as Judge Grimm mentioned, of course, can impose civil fines, but those fines can be quite significant. And for example, in litigation involving Twitter, when it was called Twitter, they were held in contempt for not providing certain documents that the court ordered disclosed. The court imposed a fine which doubled every day. Within 3 days, it became over $300,000. And Twitter, as well resourced as it is, as it was, Twitter complied. Those are significant tools. But at the same time, I don't want to be misleading about this. So you will see an expanding circle of defiance if the executive is really determined to push this confrontation. More and more actors would have to be involved in refusing to comply. So, for example, the courts do have powers of criminal contempt, including putting people in jail for noncompliance. But the U.S. Marshals are the ones who actually do the arresting and putting someone in jail. Now, the U.S. Marshals are in the executive branch, although by statute they're obligated to, do what the courts require of them. But if the president, wants to up the ante and order the marshals not to comply, we don't know, what they would do in that circumstance. But you can picture this, ongoing escalation. But the country will be in tremendous turmoil, if we get into that kind of dynamic. I would expect the markets to reflect this kind of turmoil and uncertainty. At some point, if we really got to this stage of a true ultimate confrontation like this, the weight of public opinion can play a significant role. I think that's what happened in the Nixon tapes case, where he realized defying the court was going to leave him in just as bad a position as complying with the court. And as I say, all the turmoil, the uncertainty in the market and the like, how this affects the economy, all of that will come into the picture at some point if this really got pushed to the ultimate level. None of which would be good for the country, of course.
Mm-hmm. I'm looking at a lot of questions here in the chat, and while you were talking, more questions were kind of coming in. It might be beyond my pay grade to be able to filter all those and tee them up, but I would just invite you, our guests here, to glance, if you can, at some of those questions and perhaps jump in to answer the ones that you feel most suited to respond to. I will say, though, we are seeing one question here that comes back to number one, when we hear the kind of rhetoric that Tom Homan is putting forward in the public square, we might have questions about whether the defiance of judicial orders explicitly is what it's going to take to, or what will be the straw that breaks the camel's back, right? So just again, if as we kind of move on here, if you can continue to help us figure out if we've already crossed into the danger zone, the red zone, and what lawyers can do about it, especially now that we see big law sort of backing away and backing into a corner without sort of collective efforts to push back on some of these executive orders. I'm gonna open it up for you to perhaps ask each other questions or to just reflect on what's already been discussed and sort of bounce some ideas around. And in the next second or two, I'm just gonna choose one of these questions here that essentially says, what does the panel think in terms of, the federal judges facing security threats to their own personal, their lives and their families in some cases, and just how do we push back as lawyers using skills and expertise that kind of is outside of the courtroom? Where is the space for engagement, and what would you recommend to our audience?
So if you don't mind, I'll jump in on that because we've been
Please.
looking at that for the last year or so. And judges have a limited ability to engage with the public about the work that they do. As the Chief Justice himself has said many times, we express ourselves through the opinions that we issue, and we show our work. We don't just come out and say, here is the law as I see it, and walk off the bench. We have to show our work, dot our I's and cross our T's, and the higher courts for review can then look at that and agree or disagree. But because judges can't talk about cases that are before them or matters that could be before them because they don't want to create an appearance that they have already decided on issues that might be before them, they have limits in what they can do. They can engage on broad matters involving the law and the government, but they can't get into the specifics. So who will speak for the lawyer, for the judges? And if you look at Canon 8 of the American Bar Association's Model Rules of Professional Conduct, Comment 3, it says that there's a professional responsibility on the part of the bar to defend the judicial system and individual judges if they have been unfairly criticized or attacked. And that has been a tradition of the bar forever. It has been a tradition of the bar and individual lawyers to take on unpopular causes forever. I mean, we know the John Adams defending the British redcoats who were involved in a criminal trial. That took a lot of courage back then, and it takes courage, and the bar is called upon to do that. They are officers of the court. No one knows more than individual judges the importance of the rule of law, the legal system, of all those things that Professor Pildays was reminding us about, the benefits that we have always had and relied upon in the country for doing that. So the bar has to do that. So how can they do that? Well, individual lawyers can write to members of Congress and say, it is irresponsible to attack and to threaten impeachment to these. You should not vote in favor of a bill of impeachment to be issued from the House. If there is some sort of action that is designed to undermine the judiciary in ways that has never happened before, to speak out against that, to write public opinion pieces. And I can tell you that many of the widely reviewed and respected news sites and sources have increasingly been talking about this from both sides of the ideological perspective. They weren't doing that a month and a half or 2 months ago. So every time that you have an action that is a further step in the directions that Professor Pildays is warning us that we want to not go down, and Judge Gertner has pointed out that we are in closer territory than we've ever been before to these, people have to speak out, and they have to have the courage to do that. And I think the fact that law firms and individual lawyers find themselves feeling like they are in the crosshairs of upsetting the administration, that is a matter of concern that we haven't seen in this nature that I'm aware of. And lawyers and law firms are going to have to make a decision as to where their oath to support the Constitution and their obligation to the profession and to the judicial system intersects with their making a living, and they're going to have to make some hard calls. But it's incumbent upon everyone who is an attorney to think carefully about how they can contribute to that discussion in a positive way. And we should try to generate light, not heat, whenever possible. But it is also important to stress how critical these issues are, and there has to be a response. If there's a one-sided conversation and it's all criticism, the American public, we forget how complicated and convoluted our legal system can be to someone who doesn't really understand it. And we can engage with the public by trying to help them understand the benefits of what our system is and how it works and why it's for their benefit and their protections by helping them understand and doing civic engagement. That's something that any lawyer can do, as well as standing up, being willing to take an unpopular case, to sign an amicus brief that supports a position in a case if you believe that there's merit in doing that, and having the courage to be able to do those things. And I'll just tell you, when I was in law school a million years ago, our law school was right next to the medical school, and the doctors would always hang out at places after work, and they had the stethoscope and the white lab jacket that we were all jealous of. But one of my colleagues one time said when doctors were treating patients with leeches, the lawyers were writing the Constitution of the United States. I think that we don't need any sunshine patriots today. This is something that the legal profession has got to step up and lead in this area. And perhaps some people are back on their heels a little bit, but I hope and hope that when push comes to shove, the conscience of these professionals, that they'll step up and be heard in appropriate ways.
I have a to-do list. I have a to-do list. So think about all the ways in which lawyers can get bar associations to weigh in on this, local bar associations to weigh in on this to the extent that's appropriate. I've seen, certainly to weigh in on attacks on judges. The American College of Trial Lawyers has, the American Bar Association has weighed in on that, but we could think about weighing in on other issues. Lawyers can write opinion pieces, like describing things in the way that Judge Grimm was just describing it, describing what these cases are about and why this matters. They don't have to necessarily take a position, or they can take a position but justify it. They can speak at schools. They can talk to their legislators. They speak with a voice of authority that other people don't necessarily speak. You can take a cue from other countries. The bar, I believe, in places like Israel and Poland, stepped up and made statements. You can represent people, particularly at this time that we're seeing some big law firms being afraid to step forward and take on the government. You can take on the government. It's interesting that smaller firms, middle-sized firms, have been taking up some of that as well. And then, with respect to just a point that someone made before, I think it was Professor Pildes, about the marshals. If we get to a point when a judge directs the marshals to enforce a rule, and the attorney general tells the marshal do not, then we're at the brink. Then we're clearly at the brink. The statute that created the Marshal Service says that they shall enforce the law. It doesn't say they should enforce the law that Pam Bondi believes in. They say they shall enforce the law. And so presumably the marshals have a requirement, are required to enforce the law. What the practicalities of that, I don't know. But again, getting back to lawyers, you have a special role in this country, in the communities that you're in. And you should speak out in all the ways that you can to reflect a concern about these times. So I have a longer to-do list, but it'll go past our hour.
One thing I want to mention here that just pulls these comments together a bit is that we know from empirical kind of studies of various social circumstances that there are what are called preference cascades that happen. So people look to other people to see what they believe or how they act. And if a lot of people don't say anything about some issue, there may be people who have disagreement with that issue, but they will also kind of remain silent, even though they don't agree with what's happening. But conversely, if people do kind of speak out and act appropriately and with some, backbone, other people notice that, and people who have similar views are more empowered, feel stronger about coming forward themselves. And it's remarkable the dynamics of these preference cascades that we have seen over and over across many, many countries. And I think it's important to keep that in mind because, we're all social animals. We all pay attention to what our, reference groups and peer groups are doing or not doing. And, lawyers have a professional culture, and identity, and they look to other lawyers, particularly leading figures in the bar, and notice what they're doing or not doing. And there can be very significant ramifications, from these cascades as, people start taking action or standing up for the appropriate principles.
And the
And I
opposite
think
of
it's
that.
important, let me just say also, this is obvious, but it's important that this not be viewed in partisan terms or be able to be cast as being in partisan terms, because this is about, fundamental principles about our institutions and about the rule of law. And it's very important that the defense of all of that come from across the kind of ideological and political spectrum.
I think I just wanted to add that the reverse is also significant, which is the silence of the bar speaks volumes. The silence of the bar with respect to the criticisms of judges and the calls for impeachment, the sort of inappropriate comments. I'm looking at a comment that the Attorney General made about the Judge Boasberg. It says, tonight a DC trial judge supported the Tren de Aragua terrorists over the safety of Americans. It's just not true. That's just not true. And then adds that the group is represented by the ACLU. I mean, basically mischaracterizing what the case is about, mischaracterizing what the judge has done. That has to be answered, and it has to be answered in literally every forum that we participate in, from, the town council up to state and federal representatives. It has to be answered because the silence conveys a message to our representatives, conveys a message to the government that we're okay with all of this, and we are not okay with all of this. Someone in the chat wants my longer to-do list. We don't have enough time.
Forthcoming.
As I said, I mean, I think you think about all the ways in which lawyers interact. There are amicus briefs, and there are small groups now, groups that are doing the litigating, actually, public interest, not-for-profit groups that could use your support if you agree with what they're doing, not just the big ones like the ACLU, but the smaller ones like Protect Democracy that are bringing the litigation, if you agree with it, that you can support. But there are lots of ways that lawyers can speak up.
We have materials that we will link to this that can be posting. We have at the Bolch Judicial Institute Defending the Judiciary website, we have a list of immediate actions that can be taken, moderate terms and then long term. But one of the ways of just simply engaging with the public. I mean, people like origin stories, and we've been doing some outreach, judicial education in the workplace to adults who maybe didn't have a lot of civic education, or if they did, they haven't really remembered it. Most of the American public has very little contact with the judicial system, so they don't understand. But one of the things that when you explain to people resonates, our system, our constitutional system requires checks and balances. That's messy. It's sloppy because each branch has the right to check the other branches from exercising excessively dominant control over the government. And that's required. It was done on purpose because it was the experience of the colonies that there were abuses. And the Chief Justice referred to that at the beginning of his message at the end of the judicial state as of 2024. And when you realize is that these checks and balances, which require that the judges exercise judicial review as their checks on what the legislature and what the executive department can do, are critical. It was built in to what the founders of this country felt was important to protect our freedoms. And when you realize that this tradition has been going on and has been clear from the beginning of the country, done with purpose, then you can have a little bit better understanding. And like Judge Gertner said, to criticize judges who've issued a 14-day temporary order to preserve the status quo until the opposing sides have a chance to be heard, this distorts the narrative, and it misinforms, which does a great disservice to the American public, to try to minimize the importance of the complexity of these issues by simply plastering labels and applying dog whistles to try and get an emotional response devoid from an understanding of what is important here. And that's the hope that we have, as Professor Pilday said, is that at some point people start to say, well, now wait a minute, this seems to me that this is not going in the direction that it should go. And so all of us have roles we can do, but the bar, as Judge Gertner says, has a particular responsibility. They are officers of the court. They live within the judicial system, and they know its importance. And they just have to find a way consistent with their conscience and their understanding of finding a way to have their voices heard in a positive, constructive way. And that's what everyone really should be thinking about, how they can be engaged to do.
Mm-hmm. Mm-hmm. Since we do have so many questions that seem to be pouring in, I would love to try to just, Professor Pildes, ask you if you are able to respond to a few of them in short order before we kind of close out here. But if not, I will take that one right back off your plate, and I will make a few suggestions on Judge Gertner's list and add to those concrete things we might consider. It's a tough one.
Okay.
There's so many questions out
Go
there.
ahead.
So, okay. Well, I guess the question that I see here that's been kind of cropping up is related to what should big law firms, and we've already had some response, and Judge Grimm has commented on this, but what really should big law firms, what is their responsibility at this moment? And, Deborah Pearlstein had a great piece today suggesting that there's got to be collective solidarity here. How does that happen? I mean, how do lawyers make that happen? And I just want to come back to that one for you specifically, Professor.
Yeah, so I guess let me start by saying there are a lot of lawyers in the country who are not part of big law firms. The big law firms, I think, have become as much businesses as kind of, professional organizations of lawyers. I think firms that not quite at that level often have sort of more that sense of professional identity and the like. And I think Judge Gertner mentioned that smaller and mid-sized firms have been actually the ones so far who have been speaking up about some of the attacks on law firms. But I think the larger point is right, that as always, there's strength in numbers, that isolated institutions, isolated individuals are much more vulnerable. Each actor has its own self-interest that it's calculating. But if people feel that they are part of a larger mission or a larger kind of not political, but legal culture, and if they're reminded of what it means to be part of that legal culture, and what their obligations are to the courts, to defend the courts, to protect the courts when they come under these kinds of attacks, again, the more it starts happening, the more of it you will see. It will be a cascade. But it takes strength among the early movers to, actually be the ones who are initially out there somewhat more isolated. But I hope that that leaders in the profession are, speaking to each other, discussing these issues, talking about what they should do, what they can do. But again, it is strength in numbers in a situation where institutions are under attack.
Let me just say that there are a number of organizations that have already been doing just terrific work. The American College of Trial Lawyers has been a staunch supporter. These are the best trial lawyers in the United States from firms of all sizes, civil and criminal lawyers. The American Board of Trial Advocates of BOTA has a very robust presence here. The American Bar Association, of course, has been doing this. There are many bar associations, regional, local, national, subject matter. All of them have individuals that can speak out. And what has to happen is at every instance in which there is a new challenge, there has to be another appropriate response to address that, because in the absence of a response, it creates one narrative. And when that is the only narrative which is there, then the public, which this ultimately affects, and we have a responsibility to try and help the public understand this is their legal system. And all of the things about what we think about this country as a country that is something, that a country that we love and that we have pride in, has these institutional protections in there designed to have this, to protect our rights and interests. And as the public can understand that, there's a very strong positive narrative about what the courts stand for and what judges can do. And that's an example. You want to talk about what judges do, do an article about problem solving courts, the courts that are their veterans courts and courts that are doing things to help people, so the public gets an understanding that judges are public servants, most of whom are working really hard, and much harder than what they're paid to try to do the public's work. And this notion to try to vilify them and to personify them as somehow trying to thwart the public interest is simply not a true story.
Thank you.
I just want to chime in. I have one silly thing to say and one not so silly thing to say. My husband says that now that I can speak, I can't shut up. And there's something to that. I don't believe that any of us can shut up in the face of what we are seeing. Taking again from Timothy Snyder, the importance of using your expertise to speak truth to power, wherever that goes on, engaging in collaborations across disciplines. That's really critical. And I suppose the other saying, which is not as funny or as silly as what my husband says, is something that actually the title of Howard Zinn's autobiography, which is "You can't be neutral on a moving train." Mm-hmm. And the sense of the powerful changes that we are seeing in institutions we desperately care about. You can't be silent and you can't be neutral as the train is moving down the track.
Thank you for that. I think that is a very important note to end on here. And to close out, I do know there are a lot of questions we didn't get to, so we will hopefully try to do that in a follow-up. Everything ranging from whether it would be appropriate, Judge Grimm, to bar an attorney for continuing to represent a party, the DOJ, for example, if that attorney defies a court order and lies to the court about his or her actions. What do we do there? Or we have a situation where judges are confronted by lawyers but aren't able to get the evidence to resolve essential facts. So, again, when the DOJ doesn't function as a prosecutor properly, how do judges compel that type of testimony? What about Federal Rule of Civil Procedure number 11B? Will judges bring that in terms of sanctions? I know I'm firing now a lot of questions and we're basically out of time. But moving, if we have a few more minutes before we really close out, just to say, for my colleagues who haven't already posted things in the chat in terms of this long list of action items. We know that there is a letter circulating. All lawyers can sign on to that. Please volunteer. Please reach out to us, the task force. We would love to work with you and again, follow up with you and send you constructive things. May Day is going to be, May 1st, that is going to be a big day where our lawyers will take their oath. Again, it's a state and countrywide movement now. That is something to keep your eye out for. So there is a lot going on, but we've got to work together and try to communicate about a lot of these opportunities for lawyers. And again, just to say thank you, showing up and being here and taking the time and interest is enormous. And we could not be more grateful to you, Judge Gertner, Judge Grimm, Professor Pildes, for your incredible leadership, your service, and your inspiration to all of us as lawyers and members of the public. Without you, this conversation would not have been possible. And I think we will move forward carrying a lot of these messages that you've shared with us. And again, just cannot thank you enough for everything, and onward. So thank you.
Thank you.
Pleasure.
Thanks
Thank
very
you for
much.
allowing us to be able to share this time with you.